to the July 10th, 2024 meeting of the Brentwood Planning and Zoning Commission. I'd like to call the meeting to order. And first order of business, if we could, it would be the Pledge of Allegiance. If you could please join me.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible.
Thank you. Jessica, if you could please call the roll.
Mark Favazza.
Here.
Swearing.
Here.
Jeff Moore.
Here.
Jeff Hunt. Carl Carlin.
Here.
Jack Shelton.
Here.
John Nernberger.
Here.
Hart Nelson.
Here. Thank you very much. We have a quorum.
And Brian Nolan.
All right. The agenda has been disseminated. Are there any adjustments or changes to the agenda? If not, any objection to approval of the agenda by acclamation? Seeing none, the agenda is approved. Next order of business is the approval of the minutes from May 8th, 2024. Thank you very much. And I actually... June 12th. We are in July. Any objection to approval of the June 12th, 2024 minutes? They have been disseminated. Any objection to, or any alterations or adjustments that need to be made? Any objection to approval by acclamation? Let the record reflect the June 12th, 2024 minutes are approved. Do we have any citizens wishing to address the Planning and Zoning Commission on items not on the agenda this evening? Seeing none, we'll move on to old business. Our first item is P&Z 2408. This is facade and parking lot improvements at 8031 Litzinger Road for Carboline Global Incorporated. Is the applicant or the representative here this evening? If you could please step forward, state your name and your address, and let us know a little bit about the application this evening.
You bet. Evening, everybody. I'm Tim Ellie. I'm the owner's representative for Carboline. I work for Gershman Commercial Real Estate. My address is 323 Wild Forest in Baldwin, Missouri.
Thank you, Mr. Alley. Please tell us a little bit about your application this evening.
Sure. As you all know, Carboline experienced, just like a lot of Hanley Industrial, was flooded and gutted a good portion of their property. They did decide to rebuild and stay after an analysis on whether or not it made sense to reinvest in the floodplain. They did decide to make that reinvestment and have also included floodproofing. With that significant investment, as the project evolved, they said, you know, we've really spent a lot on this facility. We'd like it to look a lot better. And so that's what you see in front of you. Does everyone have the report in front of them? Probably page 2 of that report is a good place to start.
Sorry, Mr. Alley, you talking about the elevations?
Yes.
Okay, thank you.
Oh, great. So right now we have a nondescript CMU, painted CMU building. And this elevation is where they welcome a lot of students for training for their products. So they have a lot of classes that they hold. And they just want this facility to reflect the quality of their product and the quality of their company. And to do that, there aren't a whole lot of options for changing the shape of overall architecture, other than putting a more interesting skin on it and getting some sunlight into the building with some windows. So if you'll see that there are 2 versions here, one that has a Trespa panel with some significant glass added, and a plaster finish below, just really a clean finish. The second one shows a covered entry and pergola. This is a functional improvement for Carboline. One of the reasons is for, obviously, when you're getting into the building, you're not getting drenched. The second is when the students are in class, sometimes they need a break. It's a full day. And if they can get some sunlight and some fresh air, it can kind of really refresh them. And there's just not a lot of area around there for students to congregate, maybe have a sandwich and get back in refreshed and ready for class. With this, we're also revising the parking plan, which simplifies it. It puts more ADA parking close to the building, and it also improves the landscaping. We think this is a very significant investment for Hanley Industrial, which, as you know, is struggling to keep tenancy. In my role in the commercial real estate business for Gershman Commercial, I think Carbline's investment could show other businesses how they can stay and how lease rates could rebound. Even though you have a significant challenge of floodproofing. The unique part of some of these buildings is that they aren't littered, or littered's probably not the best word, but they aren't full of holes for windows like an office building would be. So floodproofing, while expensive, is possible. I just don't think many of the landlords in the area know how to go about it, and I think we're kind of on the front edge of that. So from a neighborhood perspective and from an industrial park perspective, I think when people see these improvements, both aesthetic and functional, we'll actually see a nice rebound that could come from some of these vacancies due to floods.
We'll go to staff report now. We'll go to staff report now. If we do have any questions, we'll ask you to come back up to the podium, though.
Thanks a lot.
Or unless we have questions, sorry.
Before I start, you do have the material samples if you want to just start passing them around.
That'd be
for the
excellent.
board to
Appreciate it.
see. Okay.
Thank you, Ms. Kelly.
As the applicant indicated, Carboline is a large tenant. They occupy 350, 360, 370 Hanley Industrial Court, and this building as their training facility for their product. This area was originally, and this building was originally developed in 1955, so there is some pre-existing nonconformities on the site, including the parking in front of the building, which it currently straddles the property line and into the right-of-way. And that the building sits 35 feet from the front property line, where our current code requires if parking is in front of the building, it should be set back 50 feet. Therefore, the pergola that is being requested is up for review at the Board of Adjustment at the end of the month. They were originally scheduled for the June meeting, but that got canceled due to a lack of quorum. So in an effort to keep the project moving forward, I really wanted to get y'all's input on the overall design. And if you had any questions or concerns regarding the change in the site and the parking, we can get those addressed while they're seeking the variance for the pergola. And then we can keep them on track for Board of Aldermen review. They are adding some landscaping to the front. They're shifting all of the ADA parking, most of the ADA parking to the front and shifting it entirely onto their property line. I did discuss this with our traffic engineer, and he said that he didn't raise a large concern as it is a pre-existing condition, and it can be found throughout the light industrial district because of when the properties were all developed. Since they're not increasing the degree of the nonconformity, I didn't feel like the parking shift, and they're actually improving upon an existing condition, that did not require the variance at this time. But if you have any concerns, that is certainly something we can get addressed. They are also adding some landscaping to be in compliance with as much as possible with the landscape requirements. Our landscape architect, Andy Frank, is here, and he can provide any direction. His information is in the staff report. Would you like to?
Frank, please. Yep.
Good evening, Mr. Chairman, members of the Planning and Zoning Commission. My name is Andy Frank. I'm with the Planning and Zoning Architect. So we reviewed Carbline's first submittal. And we had comments to the landscape plan section and 3 site plan section. The petitioner resubmitted their plans. We reviewed that, and they essentially complied with everything except for 2 items that were left open on our most recent report. The first was they needed to submit a revised electrical site plan to show that the proposed parking lot lighting conformed and there was no spillover. It was hard to read where the parking lot ended and where the property was. So we asked for that. We have not seen that yet. I don't know, Whitney, if they've resubmitted that or not. And secondly, we just wanted to see an example, or wanted you guys at least to see an example of the proposed screen for the HVAC equipment on the roof. So those were our 2 comments. We're kind of waiting to see the submittal on those 2, but other than that, we had no additional comments. I don't know
Mr.
if-
Frank, we're talking about the existing, there's no change to the RTUs, the rooftop units that are there? It's just going to be a screening for it, is that my understanding?
Did you say that again?
Sorry, I'm looking at the existing building right now. Actually, it's a dated image of 2022, but the rooftop units that you're asking for screening, they're not being changed, is that correct? It's the same units, we're just asking for screening?
We understood that they were actually changing that equipment out. It was our understanding. It might not be correct, but that was our understanding.
We'll inquire. Thank you, I appreciate that.
Any other questions?
Any other questions for, actually, we'll try to ease it a little bit. Any questions for Mr. Frankie, and then we'll go back to the petitioner. Thank you, Mr. Frankie.
Thank you.
Appreciate it. Mr. Elliott, if you could come back up. We may have some questions for staff too, but we'll ask that one first. So it does sound like the HVAC unit or the HVAC equipment is going to be changed out a little bit, and then there'll be some screening applied. Is that correct?
Right, we're working through the screening design. The building owner wants the same thing. You know, obviously, they're wanting this to look as good as they can, and they're not going to go that far and not.
And not screen.
Yeah.
Understand. Any questions from members of the commission for either the petitioner or staff? Mr. Carl?
Just a comment. I think it looks great.
Thank
and
you.
it'll be a nice addition to that area. I go by it every day walking the dogs, so it'll be nice to see it. As far as the rooftop screening, that's a plus. Is we fight hard to get that, and we often don't. So it'd be nice to see it. That's all. I think it's a nice thing. So pergola, definitely.
Thank you.
I will say, in talking with the applicant, they're looking into the rooftop screening, but there is a concern that regarding the structure of the roof current, so that's why it's taking a little time.
Yeah, there's various ways we can achieve it. We just don't know how yet. You know, these buildings it's a retrofit, so we have to figure it out.
Any other questions from the commission? Mr. Moore?
Thank you. Sir, do I recall that Carboline appeared in front of this committee and the Board of Aldermen a few years ago regarding a furnace or some kind of blasting unit? Is that in this building?
So I don't know if they appeared. I suspect they did, because they did a few years ago build a separate building for a furnace that they use. They do testing for their products. They create the standards for their products, and they have a big furnace facility there. Right.
I'm just trying to, I know it's a little outside of our purview, particularly for this application, but just the floodplain.
Yes.
Did that get protected and everything's?
That portion, luckily, is outside the floodplain. So the floodway goes through a good portion of Carboline's property. When they made the investment in the furnace, they did it because it was uphill of where the floodway is.
All right. Thank you. I can sleep well tonight.
Yeah.
Thank you, Mr. Moore. That is better than mine, because I do remember that now, too. Any other questions from members of the commission? If not, I will entertain a motion. I do believe that it may be appropriate, if I could suggest that the screening be included in any motion, and perhaps that it's acceptable to staff after review, so we don't have to have a second decision on this. If that is, I don't know if that's in the staff report, but
No.
I think screening may
mean,
be a requirement, though, is all
Yeah,
I'm saying.
rooftop, that is one of the recommendations. So so we're recommending that you continue this so they can get the variance for the pergola.
Excellent.
And then at the next meeting, if y'all we can review the rooftop screening and the recommendation for the lighting they'll be able to address those at that time.
Excellent, and actually, it was a question that I had made a note and didn't ask, is the applicant, though, just so that the commission is clear, if the variance isn't offered, are the rest of the improvements planned? Again, I think that it looks better, from my personal opinion, with the pergola, and would certainly hope that that may be considered, but is that something that the applicant is willing to move forward with, that basically there'll be improvements regardless of that?
Pergola is not approved.
Approved through the
We
variance.
still do the front elevation.
Basically the first proposal.
You know, they want that front door
Yep,
looking as good as they can. You know,
just,
I wouldn't even try to say, oh, approve our pergola, we'll give you the.
no, it just, there's two renderings proposed, one of them's with
Yes.
pergola, one's without, so I guess I would say is that we would see that those are both possibilities. I think that there's a input from the commission that we prefer that, but that's up to the Board of Adjustment, not us, so. All right, thank you, Ms. Kelly. Any other questions? Any members of the public wishing to address the commission on this application, online or otherwise? Seeing none. All right, and so again, staff recommendation is that we continue this after the Board of Adjustment has, or the variance, excuse me, has been approved. Do I have a motion?
Chairman,
Ms. Sharon?
I move to continue the discussion of the site and building improvements at 8031 Litzinger Road to the August 14th meeting.
I have a motion. Do I have a second?
Second.
Second by Mr. Moore. I think that voice vote be enough. All in favor signify by saying aye.
Aye.
All opposed, same sign. We will continue this to the next Planning and Zoning meeting. Thank you very much for your presentation this evening, Mr. Elliott. Next item of business is new business. We have P&Z 24013. This is a CUP, a conditional use permit for Planet Fitness within the address of 8340 Eager Road within the Meridian at Brentwood Development. Is the applicant or the representative here this evening? You could
Hello.
please state your name and your address for the record,
You got
please.
it. Corey Pritchard, Avison, Illinois, 14337 North Fork. I'm a representative for Planet Fitness, work with M2 Studio Direct, who submitted the application, I believe. So I believe this is pretty straightforward, or kind of called a revitalization of the Bed Bath & Beyond space. Items relevant to this meeting, I think, are we're wanting to install a window on the front face of the building. Aside from that, it would really just be signage. No even color change, I believe, to the front of the building or anything. Other relevant items would be parking. I think the number was around 182 spaces required, something like that. And given the space out front and the parking garage below, seems to be able to accommodate. Utility use doesn't seem to be a huge impact as well. I really don't know what else there needs to be discussed, so I'll just kind of leave it at that for questions, I guess.
All right, and we'll go over to staff report, Mr. Pritchard. Appreciate it. Ms. Kelly?
Good evening. The subject property is the applicant seeking approval of a conditional use permit for a recreation center, health club in the PD district, which requires the conditional use permit, which is why we're here tonight. Similar to the discussion we had at the last meeting with our Activate Games, they are taking up the former Bed Bath & Beyond space in what was Building 2. It is a 32,807 square foot facility that will be operating 24 hours, 7 days a week. The only exterior change I have noted here is this window. And overall, that's the only exterior change to the building or the site. As we discussed at the last application with the Activate Games, the landscape architect had noted that there was some missing dead trees. The applicant, the property owner, has provided a statement that they have under contract to remove the dead trees and will replant them, new ones, in the fall. And we are fine with that. That would be in line with any of the building. But we will just have that as a continuation, have that condition as a continuation, since similar to the Activate Games. The parking and circulation, the CBB did not have any concerns with the overall parking. However, the fitness facility does represent a 60% increase over regular retail. And the development has sufficient parking. He didn't have any concerns, but he did note that the front may seem crowded. But the overall management of the parking would be up to the property owners. And given, you know, the different hours of operation of the office uses and this use, he didn't really foresee a concern. If there is a concern, it would be up to the management to help direct people, the staff, to park underneath or in the garage so that the surface parking is more for their clients.
Ms. Kelly, there's a parking garage, so I know that there's one attached to that section. Is the garage across the street also considered part of the parking for this development? Okay,
Yeah.
thank you.
That was for the Metro
Yep.
back here, yeah.
Yep,
A 6-story garage, a
Yep.
10-story Metro garage available.
okay.
There's parking underneath the building that was noted, yeah. So overall, we don't have a large concern with this use and therefore recommend approval.
Do we have any other of the businesses in that development that are operating 24/7, or would this be the only one?
That I'm not sure. I don't think there's any others that operate 27.
Mr. Pritchard, can you provide comment on usage, again, since it is going to be unique in that respect, in terms of your customer base, just general trends? How many folks are using it at 2 in the morning, that kind of thing? Do you have any kind of general
so peak
ideas?
hours are going to be 4 to 6 in the morning, and then that 4 to 8 at night.
Okay.
That's when we get our peak uses typically. Facility like this, we would expect approximately 12 to 15,000 members ultimately. I know that seems a little wild, but on a daily check-in basis, you'd be looking around 2,000 on a daily check-in basis. That's a pretty high number for us. I think this is looked at to be a pretty solid club. So 1,500 to 2,000 check-ins a day.
And how long are they normally in the facility for?
Call it an hour, yeah. And again, you're getting the bulk of those in those two windows there.
Questions from members of the commission? Please.
I have
Mr.
a
Schell.
question. So 24 hours about security. Is it staffed 24 hours a day?
Staffed
I
24
asked
hours,
just because previously, in a prior role I was with the city, there was a gym, Club Fitness, if you remember, was 24/7, and there were some security issues with the parking garage overnight, but they were not staffed overnight. It was key card entrance. Will that be the?
No, anytime it's open, there'll be staff. I think a minimum of 2 staff anytime we're open.
And then, Woody, is that, if security becomes an issue, is that up to the building owner? Or, I mean, obviously they work in conjunction with the police department, but ultimately who is responsible for?
Question, maybe our attorney would be able to,
You think?
yeah.
I don't understand the layout enough to answer that. Can you help me understand?
So I'm just, I'm just 24/7, it's a new overnight use, right? If there were security issues, at what point does the building have to get their own security? Obviously, the city would increase patrols and whatnot, but
It would, I would expect that would be a decision of the tenant and the landlord with respect to their liability risks.
Okay.
And how they wish to manage that risk. And so I would expect that's going to be a private decision. And in general, I don't think we mandate security. Among other things, I don't think we want to be responsible for
Yep.
determining the security arrangements on private property.
From experience, he's correct. It becomes a landlord-tenant argument. Of course, we want the landlord to have some liability in that, responsibility. I mean, yeah, I'm not going to say that we wouldn't reach out to the local police department to say, hey, can you do a couple extra drive-bys here and there? But it is an issue at some of our facilities. And then also based on trends and based on any of that activity, we may deviate from a 24/7 club too. We do have ones that just aren't open during those certain hours.
But you answered the question, will be staffed.
Yes.
Of the overnight hours. Thank you.
Sheldon, any other questions? At this time, actually, any questions from members of the public wishing to address the commission on this application? Seeing none, Chair will entertain a motion. Mr. Carlin.
I move to recommend approval of the conditional use permit for Planet Fitness within the Meridian at Brentwood Development within the tenant space addressed as 8340 Eager Road and including the conditions discussed at the July 10, 2024 Planning and Zoning Commission meeting.
We have a motion. Do I have a second?
Second.
Second by Mr. Shelton. Actually, let's do roll call on this, please, if we could. Jessica, since we have a vote.
Mr. Favazza?
Yes.
Ms. Sharing?
Yes.
Moore?
Yes.
Yes.
Carlin?
Yes.
Mr. Shelton?
Yes.
Mr. Nurnberger?
Yes.
Yes.
Thank you very much. Appreciate the application. This will go to, well, we'll talk about to the Board of Aldermen, actually,
Yeah, on August 19th.
August 19th.
Thank you.
Same location, same bat time, same bat channel. All right. Next up, we have P&Z 24014. This is comprehensive sign plan for the shopping center at 8500 Manchester Road. Is the applicant or their petitioner, or excuse me, or their representative here this evening?
Yes, sir.
Good. State your name and address for the record, please.
I'm Michael Schutte. My home is in Oakland, Arkansas, and I have a place up here in St. Louis, but my address is Oakland. And I'm here today on behalf of the landlord, the owner of the property, to help them to get a sign for the building to replace the sign that was taken down during the improvements to Manchester Road. There was a large pole sign that's in the application pictured that was in the area where the sidewalk became the 10-foot sidewalk. And in order to, in the redesign, the state created an island at the only remaining entrance to the center for these 12 different tenants in the building. And we'd like to put up a sign there that is within 10 foot of the property line. And so because it's within 10 foot, then we have to make a comprehensive sign plan. So in the permit application, I made a list of all the signs that are on the property. And in the month or so that I've been talking with Ms. Kelly about it, she's come up with a couple things that she's concerned about. And I'd like to address those, and then also make sure that what we are asking for is to be able to use the property with the signs that are on it right now. And add a ground sign that's 60 inches tall by 12 feet long in this little island that is at the entrance to the subdivision, or to the property. There's each of the signs on the building, the main part of the building, are pretty far back, and each bay has a sign. So if a tenant has rented two bays, they get two signs. We designed a sign that would allow for each of the bays to have the same size of a representation on the ground sign. If for example, if the Strength Works would move out, which has two bays in it now, then I would have two little sign places on the red and white sign for the new tenants. If a new tenant was two people, or one person had two bays, they get the same space, but we designed it so that everything's done with black Helvetica letter with a good amount of white space, so it's easy to read as you're traveling down the street. No logos, no colors, so that the sign is very informative. Um, I think it's important to have the address on the sign, and we would like to use the base of the sign going east and west to put white letters on it and put the street number on it. I'd also put it on the part that faces the street so that if somebody's driving down, you can see those numbers. They'd be white on the red background, they wouldn't stand out very much, but if you're looking for 8500 to 8518, you'd be able to see those numbers pretty easy. We'd like to ask that, I mean, since everything's on the table in a comprehensive sign plan, we'd like to ask permission to keep the B for the Budweiser above the bar and grill should we get a tenant, which they're working on a tenant that would have a bar and grill. It sits in the middle of the building, and it would be a good way to mark that property should a person who they're working with lease those for a bar and grill. If it weren't a bar and grill, then I would say that it'd probably be a good idea to take that B down and eliminate it. So if it became another fitness center, if we put 3 in there, then take it down, you know. But I know everything's up for discussion. One of, in the correspondence I had with Ms. Kelly, one of the concerns was the possibility of this sign not being, or it being a traffic hazard. And so I went and made a banner the same size as the sign. And I've made a copy of this, each one of these that I can give to you. But I made the banner, and I put it in the position where can I hand them out?
Yeah, go ahead.
Okay. Direction. Banners. Feet on the front of the property, so we can get a 60 square foot sign. That's what we have here. So I took a picture on page 1 of the sign in the exact location where we'd like to put the sign. The red and white temporary Brentwood Center sign is 3 foot away from the inside edge of the curb. It's in and then it's 12 foot long, and there's 2 feet at the other end closest to the buildings. You can see where I parked my pickup truck. The parking lot blocks the view of the sign. On the second page, you can see the car using the entrance and the exits, going both in and out. And what happens is, to this section of the sidewalk in front of the sign, so you got 3 foot in front of the sign, a 10-foot sidewalk, and then another 5-foot little island with all the pretty flowers and trees there. And if there's one Toyota pickup truck parked in front of it for the view from the west, you can see that you can't see the sign or behind there. So, I mean, all the parking's gonna block what's behind the little white car on page 2. But that's the way the government's got it designed, and they must have thought it was safe enough, or else they wouldn't put all the 20 parking spots across the front there. Page 4 shows you a crude drawing of my handwriting with the computer showing the 5-foot by the street, the 10-foot sidewalk, and the 3-foot before the sign starts. On the right-hand side, my sign is 12 feet long, and there's 2 foot at the back end, so that when people come around the corner, I don't think they'll have a problem. And I've put it, because of that weird shape on page 4, I've got the sign lined up in the longest section, so it's far away from the entrance, and for safety reasons. The next couple pages show you a larger picture of what the other one that I had, and the final one on 9 shows my truck parked in one of the 4 parking spots by the Blues Athletics, and shows where, you know, a car can get in and out, and the car has plenty of room to see left or right to get in or out of the center. So, I hope I've, anyway, I think those are the main points of what we're trying to do. We'd like to leave the center look like it is, except for adding a sign that would be safe and pleasant looking to for the community. And that will work for many years should, like say Blue City moves out and they put 3 people in there, I got 3 spots to put them in, and same thing for Time for Dinner or Strength Works, or the current one that's open now, which is the old bar, Sideline Bar and Grill, had 2 spots. So there's two strips open for it. We'll make this sign so that, put a panel in for 3 people, same size letters, you know, so it looks like what's in the application. Plain black letters that are easy to read with a lot of white space around it. So that's what we find. In the application, Ms. Whitney asked me for a landscaping plan, and I talked to the owner about it, and, you know, I think that grass is the safest thing to put there, because it's not very big, and anything you put there is gonna block the view of the sign and impede so I think a good lawn will be the best, and that's what the owner wanted to do. So that's what's in the application. Just so you know, there is an easement. The state of Missouri has an easement in this same area, and they've given me permission to put a sign 3 foot away from the property line in their easement. And that's in the application. I don't think there's anything else. I mean, I'll let you talk about it, and then you can ask.
Thank you, Mr. Sheedy. Staff report, please.
So, as we have seen a number of these, now that the MoDOT project has been completed, they are coming through, where the prior existing non-conforming sign was taken down. There are a number of things I would like to address or get this commission's review on, and that is prohibited signs under the chapter are roof-mounted signs. The existing Budweiser's over the sideline bar is the one inconsistent element for that strip of tenants, and therefore staff is recommending approval to remove that sign. As we've discussed before, the comprehensive sign plan is to keep a consistent, better design of overall signage, and therefore allows for the flexibility. And so that is the one element that we thought was inconsistent and is actually prohibited under the code, and therefore should be removed. The code also says that when a tenant with a non-conforming sign has a cease operation, then it should come down anyway, and the sideline bar has been closed for over a year now. So The other element I wanted to get your input on is under the ground signs. Specifically, the code says that the ground sign must display the street number in addition to the sign language, and that it does not count towards the area limits of the sign, but the area allocated to the street number may not be larger than 4 square feet. And then further down, it requires that the maximum height of any sign is 5 feet above grade, including a base of not more than 12 feet in height measured in accordance to the
12 inches, I assume.
12, yes, inches. I apologize. So to me, that's always been indicated that the design of the sign should have a base where there's not text, otherwise it gets lost in the grass and landscaping, and therefore I have asked prior to applicants to move it off the base and include it as actual part of the sign area, because the way I read the code, that is the intent. So therefore, having the sign, the address numbers on the base would be inconsistent with that code. So that is, but the applicant is seeking the ability to provide for up to 12 tenant spaces. So it can be limited. That's that one. Overall, the landscaping, our landscape architect felt that was fine for this location, given the MoDOT had provided landscaping along the front as part of the upgrade. So I have included, there were designs for that on page. Sorry, page 5 and 6. So with that landscaping, I believe Andy, and he can certainly address this, did felt that the proposed was fine for this location. CBB and staff did have a concern regarding the visibility of this, blocking the visibility of the sign for those entering into the site. And those backing out of those parking spaces right next to the sign. That's why the applicant has provided the information that he handed out to you tonight. So if you have a concern about how to address that, I mean, the site is pretty limited. So how y'all want to address that would be up for discussion.
Ms. Kelly, so on that, I have a number of concerns that I just want to put out here, but just on that, I don't see, and I agree with Mr. Schuette's point of it's not a site blocking for exiting the lot, it's for backing out. Is the site itself at, I guess I would say, do they have the ability to eliminate parking spots? I also understood Mr. Schuette's point of, parking is allowed to that point. That's where the parking lot is. Of course, that's based on the fact that there was a addition or a non-conforming ground sign that was 12 feet in the air sort of thing. So that was very different than what we're proposing right now. Is there ability to eliminate parking spots in the existing lot, or would that bring us under the minimums required by code?
I have
Do we
not
know?
done a parking
Okay.
study.
But that's not what's being put in front of us right now.
But that's not before us. The site was pre-existing, so there was parking there. That's why they
Yeah,
stayed there.
that's why it's there.
Yeah.
Okay. Just a couple of the other things. Again, I take the staff report's concern about the B for Budweiser, which is not allowed. I guess my question, Mr. Schuette, which you've raised, is if there's parking in those spots right now and it blocks the sign, and I know this is a basic question, but I just want to understand, why even have a sign if people are going to park in front of it and it's not going to be visible? I understand, but if it's not even going to be visible because you're going to have people parking in front of it, what does it matter?
Not always that somebody's gonna be parking there.
Okay.
It's that, I parked my truck there to take pictures and so forth.
Understand.
And, wants to do the best she can for her tenants.
Understand.
And so, I think it's the owner that wants the sign, businesses want the sign. It also marks the entrance to this, to the center, where there used to be two. It's real easy to tell how to get into the place if you got a sign there.
Right.
That little red, 4x4 sign that I got up there now that's 6 foot off the ground really works well. I told her just leave that, but that wouldn't last very long. But, you know, I think she needs a sign to mark the entrance to the subdivision or to the complex. And in your discussion about whether or not cars can be seen backing in and out, you got, I think, the only parking spot that would have any issue with being able to be seen would be the one that would be right next to it where I had my pickup truck parked in there. And I think you'd find that there's plenty of visibility before the sign in that 3 foot that's away from the curb. And then as you back out, it's right there. Most people, you know, if they're gonna make that right turn, if they're gonna park there, they're gonna be careful backing out. I think it's still a safe spot to park. Drove by there on the way here, and sure enough, there's a guy that's in the Blues Workout Center. He parked right there, and they backed in, which is kind of smart because then he can see how to get out. But I think you got enough room to see around there as you back out that it's not going to be a hazard for those people.
The other question, I guess, that I have, and looking mostly, I think, Ms. Kelly for staff is, I know that we've talked about some additional comprehensive sign plans along this, especially with changes to Manchester. I also believe it's been a practice that not every single tenant gets a sign. I mean, it's the fact that there is a limited, so my understanding, and just make sure I'm understanding this correctly, normally it's a 12-inch for the base, 5 feet total. And now what we're being asked for is a 12-inch base and 5 feet up from base, so a 6 foot total for the sign. Is that correct?
No, he did keep it at 5 feet.
Okay, so it's 5 foot
his
total. Okay.
5 foot total. It's just normally, my interpretation of the code is that the base should not include the address. So they've included the address on the base. Now, if you're fine with that tenant here, but I would also like since I wasn't here when y'all created the code, and it's a separate line item, which is why I'm making that interpretation.
Right.
If y'all feel that's differently, then I would be happy to open that up for those that don't require a comprehensive sign plan.
But we're also being asked to consider that there may be a line for every single tenant.
Right.
And that there'll be the ability to change that as tenants change.
Right.
Rather than prioritizing larger tenants, which I think has been the practice of this commission in the past. Okay. I just want to make sure I was understanding that.
I would also point out that I didn't address is that the tenants in the shopping center to the back that take up 3 spaces have 3 signs, whereas in like the last application.
Right.
But that, since those signs are pre-existing, I don't know if I feel they can be, they're all consistent in design. I don't know how y'all would like to address that.
Some of them aren't though. For Blue City, I think, or is it Blue City?
Blue City is the odd one out.
Because
They
that's
have their
not
own
pre-existing.
design.
Yeah, that's not pre-existing.
That's not pre-existing, but the wall signs along the strip.
Are consistent, yeah,
Are-
except for the Budweiser,
Yeah.
logo. Okay. Mr. Nuremberg. Yeah, we have a picture of it. It's a large sign. It was one of the pole signs.
Yeah.
So there were individual.
Although that, I
That
mean,
had-
was non-conforming in a couple ways, yes.
Yeah, that had 5 spaces from here, plus the Brentwood Center sign, and obviously it's,
I think it's necessary to have like 16 spaces on the sign. Look of the sign. Larger sign for bigger tenants.
Thank you, Mr. Nurburg. Mr. Carlin?
Yeah, I mean, I agree that maybe there's different graphic approaches one could take, you know, and we had that discussion with a similar project recently. However, I'm not sure, for my own, you know, sake, that we need to legislate that topic. I mean, if there's a business in there they want to sign, they should have one, right? I don't know that I would say no to that. And if I understand your strategy, if they own 3 bays, they get a 3 tall space on that sign, right? Yeah.
Yeah.
Yeah, so it could be broken up however, right?
Time for Dinner's got 3
Yeah.
in there. Brentwood has 2 units.
Yeah, each bay is a stripe, right?
Yes, sir.
Yeah,
And
so-
So if somebody would move out, if Time for Dinner move out, we'd have 3 locations
Right.
available to rent. And we'd need room to be able to put the 3 in, just like Kings and Queens.
So a larger tenant would get a larger portion of
Well,
the sign.
they get a larger portion, but the sign, the lettering itself is the same size as the rest of them, except for the one, that long, Kings and Queen Barbershop.
Sure.
I had to make it smaller. But I wanted to keep it, kind of like a roadside sign, green and white, driving down the highway. A lot of what we call white space, and then the words, so that if somebody's trying to read it, they can read it. They don't get a driver does not get the benefit of all the time we get by looking at this screen.
Yes,
They
understood.
get just a few seconds.
Yeah, okay.
So
So-
it has to be easy to read.
So I get it, and I think, again, it's a style issue. We could, I mean, I'm not sure that we've required other businesses to say, or you have to use your corporate logo on the sign, for instance, right? We haven't required that of anybody, so, I mean, whether I think it's,
First Amendment issue, so.
yeah, so whether I think it's graphically wonderful or not, I think
not-
it's functional. Yeah.
I agree, it's not the,
Yeah.
it wouldn't be the prettiest thing, but I think it'll work well and be safe. And, you know, it treats everybody equally in the center.
Yeah,
So
so-
if you got 1 bay or you got 3, you don't get to put up, it doesn't change the
Yeah, no,
thing.
understood. And so I guess I'm looking for where it runs afoul of code, as Whitney has explained. So
Well-
another question I would have then is, this is coming to us as a comprehensive sign plan, is that correct?
Because they already have signs on the walls. I mean, that's part
So,
of it.
but is the monument sign itself, in other words, do we have to do a comprehensive sign plan to get this monument sign in?
Yes, because they already have signs on the building, which is normally where signs are allowed.
That and
And
this,
the
this-
I'm sorry, the monument sign is, per code, is required to be set back from 10 feet from the property line. Therefore, they're requesting that it be 3 feet from the edge of the MoDOT sidewalk, and the property line, their property line is pretty close right onto that edge of sidewalk. So the comprehensive sign plan is required for the location of the monument sign, and then because they also want to include the address on the base rather than within the sign structure.
Okay, so, and then again, given the layout of the property, we are assuming it's impossible to follow the 10 feet. 'Cause- Right, that wouldn't work. And then, I mean, relative to the blocking of traffic, the most important, in my understanding, you know, safety issue would be seeing traffic running up and down Manchester at a high speed as you're trying to get in or out, right? And so clearly, that's not being blocked by the location of the sign, at least from the evidence I've seen, right?
I
So,
think you can get in and out
Yeah.
safely.
so I mean, as far as the parking spot next to the sign, I think there's an argument, both from the use of the sign, to your question, Mr. Chairman, because you probably can't see it coming east, right, if there's a car there. You'll always be able to see it coming west because you have the driveway there so at least as a utility coming west at all times, right?
And quite honestly, I don't think very many people park right there.
And it might become an issue where we just fix that and just say,
In-
get rid of
in
the
that
parking spot.
I don't
right,
think that's
yeah,
a high-use
so.
spot. I park there because I could put my truck there and show you that my truck will block the view of the entrance and exit safely, that safety issue, more than the sign itself.
Right, thank you.
That's,
Thank you, Mr. Carlin. Mr. Hunt?
I'm having a bit of an issue with the size of the sign. It's 12 feet long. In the past, when we've looked recently at these applications for signs that violate the setback, they've been 5 or 6 feet. half the size of this one. I mean, with the size of this sign, if they cut it down to 6 feet, they could be a foot into the setback versus 7 feet into the setback, which seems much more reasonable to me.
Also would provide
Also,
a little
it
more
would
safety.
it would drastically reduce the visibility issues of traffic.
And I think that goes to the question I raised of trying to make a spot for every single tenant rather than the priority tenants. Again, to the consideration about being able to mark an entrance, I understand that completely. I think that that is an important aspect, especially with the design of this, commercial space. But it's is someone who has a single bay get a street sign rather than the fact that they've already got a sign over their business itself. So I appreciate that. Other questions from the commission?
I kind of have a concern with the color.
Mr. Favazza.
Yes,
Yep.
I'm sorry.
Please.
Kind of have a concern with the color. I mean, the red sign doesn't really go with anything else in the plaza. I mean, everything in the plaza is black and white. Kind of.
Mr. Sheedy, was there any particular reason why red and white was chosen? Oops, excuse me.
When I made the temporary sign, I thought it really brought a mark to that location. And I don't like the way the signs on the building are made from a sign guy's standpoint, black with white letters. I think and I thought about putting that in the design, and I thought about making the whole thing black with white letters, but I think it's even harder to read when you do that. One comment about what you were bringing up about the size, if I have to make it 6 foot long instead of 12 feet long, which 12 is how much because of the frontage, that's how much we can put it, 25% of the 240. I would estimate that the letters will go down in size. They will be half as big, no matter if you have to make it 12 inches tall. And that'll make the sign basically unreadable when you're traveling at 30, 40 miles an hour.
Unless you only have some of the
But
tenants
we only
listed.
put one sign up there, yeah. Yeah, and how do we choose which person we put up there? I think.
Yeah, I think that, I think that there's,
But if,
I think that point's well taken, Mr. Hunt. So I appreciate Mr. Sheedy. Other questions from the commission? Any members of the public wishing to address the commission on this online, it looks like? Anything? No. Okay. Other discussion? If not, do we have a motion? Yeah, I think that there's concerns about this, I guess, is at least some of the feedback I'm taking from the commission. First up, I guess the question is there anything, so yeah, I understand that we can have some additional conversation there. Is there any reason that we need to go to site plan subcommittee rather than having this conversation here or having it at our next regular meeting if there's concerns from the commission? I guess I'm just trying to make sure that we understand what we'll be able to get out of that, because I think there's some concerns from the commission is what I'm hearing. And so, simply, do we need to have further conversation tonight, or do we need to hold this over to the next regular meeting? I just want to make sure that I'm clear on what we're going to get out of a subcommittee meeting that we wouldn't be able to do tonight or on our next regular meeting. And again, I'll also be clear, if we don't feel like there's merits to this, or if we want to make recommendations such as the size of being smaller, then that's something that we can do this evening and make that recommendation. Mr. Carlin.
And Mr. Chairman, it feels like there's maybe some subtlety issues with where the address lettering can go that might benefit from extended discussion that would sort of hamper us this evening with other agenda items. So.
Again, I appreciate that, Mr. Carlin, and a motion to move to subcommittee certainly could be put forward if that's the will of the commission.
I'll make a motion.
Mr. Favazza,
I'll make a motion to take this to subcommittee.
we have a motion. Do we have a second? Second. All in favor signify by saying aye.
Aye.
All opposed, same sign. This application has been moved for recommendation to subcommittee, which will be on the
July 31st at 6 p.m.
July 31st at 6 p.m. in the conference room. Excellent. All right, next order of business. We have some text amendments in front of us. Mr. Schutte, sorry. Yeah, so that basically is a more informal meeting where basically we can have, rather than sitting at the podium, we're around a conference table, we can have a little further conversation. So that's the next step. Thank you very much. Thank you, sir. Appreciate it. Ms. Kelly, we have some text amendments tonight. Next one is P&Z 24015. This is text amendments to the floodplain provisions, I'll get that right, of the Brentwood City Code regarding temporary structures. Mr. O'Keefe is going to fill us in on this, so make sure that we are in order.
Well, I'm not going to make sure you're in order, but I'll fill you in on it. This is a new provision in the floodplain regulations to accommodate concerns with temporary structures which have traditionally been placed in city parks in areas that are within the floodplain, involving community events, involving some private events that have tents or shade tents put up in association with private events or community events. And also I think that there's a not-for-profit user that has a program in one of the parks that uses some shelter tents. And we wanted to accommodate that while maintaining the integrity of the city's floodplain regulations to protect our continuing eligibility for flood insurance under the National Flood Insurance Program. So we have developed these provisions which take into account things like seasonality. Is this a rainy period of time, or is this traditionally a period when we're not going to have rain? How long is it going to be up? How is it attached? How porous is it in terms of blocking the flow of water or allowing water to flow through, so not an impediment to rising water or downstream, a danger to downstream structures. And it provides judgment to the floodplain administrator, provides guidance as to how that judgment is to be exercised, and identifies the features which ought to be considered, and allows this to be addressed administratively as opposed to because again, these are short-term. By definition, they're temporary structures. So as opposed to 3 months run-up of staff review and your review and plan and board consideration, this is an administrative process intended to recognize the short-term nature of the intrusion into the floodplain and standards to minimize their consequences and to measure whether or not there is a reasonable protection for downstream and adjoining property owners. And I'd be happy to try to answer questions.
Thank you, Mr. O'Keefe. And so my understanding is that the language proposed is entirely new language. It does not exist in the code at
That's
this time.
correct.
Thank you, Mr. O'Keefe. Any questions from members of the
We have
commission?
some- I'm not sure if this is talk about the floodplain administrator. We have some technical tweaks before this is finished, but this is the substance of it. It should be the floodplain administrator, not the building official who does this. And we also got some comments from the city's special counsel for floodplain issues, but they're not substantive in terms of the issues I know you would be concerned with.
Thank you. Questions from members of the commission? Especially the attorney members of the commission. Any questions
Now's your
from members
chance.
of the public on this particular issue? So there will be some minor non-substantive changes that
Yes,
may be
sir.
required, and then it will go forward to BOA.
Yes, sir.
All right. Thank you, Mr. O'Keefe. Do I have a motion from the commission?
Motion to approve as presented.
Most approved by Mr. Nolan. Do I have a second?
Second.
I called him out. Second by Mr. Hunt, our attorneys and residents. Roll call vote, please.
Brazza,
Yes.
Yes.
Moore,
No.
Hunt,
Yes.
Carlin,
Yes.
Shelton,
Yes.
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 I believe motion passes. Thank you very much. Next item of business is P and Z 24016. These are text amendments to section 400.150 of the Brentwood City Code regarding notice of zoning action. Ms. Kelly, what do we have, or Mr. O'Keefe, what do we have in front of us this evening?
I've got these three items.
Excellent. Mr. O'Keefe.
I'm the guilty party on all three of these. Our current city code deals with all notices required for zoning proceedings in one place, which is a very efficient way to do it. However, it's not in conformity with governing state statutes, which is problematic.
That's an issue.
For reasons which I understand, the code says that the notice required to be published for hearings before the Planning and Zoning Commission or the Board of Aldermen on zoning matters cannot be published in the newspapers used and qualified and used to publish legal notices. Unfortunately, the statute requires that notices of zoning hearings be published in a newspaper of general circulation, which is certified by the judges of the circuit court for each jurisdiction, and means that it is a newspaper qualified to carry legal notices. So we have an ordinance that says, thou shalt not publish in a newspaper qualified to carry legal notices, and a state law that says you must publish in newspapers qualified to carry legal notices.
Mr. O'Keefe, do we have any history on why the Brentwood ordinance was made this way?
I
That's
would expect it may have been written in order to support
local.
advertising in local publications.
Thank you.
So what we have suggested here is, first of all, we use the statutory language about the nature of the publication in which the notice is to be published, and that is one qualifying under the statute as a newspaper of general circulation for carrying notices. And I referenced the state statutes and the St. Louis County certification. But that is found on the homepage of the Circuit Court website, so it's all, they update it periodically and they list it. I then provide a sentence at the end of that subsection 1 that says you can also publish other notices if you want, but those publications are not mandatory. So another thing I did while we had sort of had the hood up and we're tweaking this was to suggest that some of the additional notices required and such, we don't want to provide a situation where, for instance, the city, I will give you an example. I had a zoning proceeding in another community where we published, mailed notices to property owners. We got a list from the county of all property owners within X feet of the site. And the county had not updated its ownership records for some time because they were having software problems. And sure enough, someone bought property since the last update, didn't get the notice, and then claimed that the notice was defective, therefore the ordinance was invalid, that sort of thing. So what we're trying to do is to minimize that risk that we engage in these proceedings and someone goes back and peels the onion enough to find something and try and undo the city's decision. So, for instance, you will see the language down here saying that we'll give notice to those whom the staff has reason to believe own the property. So if we get a list of owners and we rely on that in good faith, that's enough. If they've changed hands in the meantime or somebody uses a mail drop, that's on them. So, and that also that we do not bear the risk of non-delivery, especially with mail service these days. We add in here that the deposit in the post office satisfies the requirement to provide the notice, so that we don't, the city does not bear the risk that the post office fails to deliver. So what we've tried to do is allow additional notice but not mandate it, conform to the notice requirement of the statute, and also then provide a process that is reasonable in terms of notice but gives some flexibility to allow for misinformation, incomplete information, or failure on the part of other parties to carry out their end of the bargain. I would add that notice to folks within 300 feet is a very generous standard, but I'm not here to try and unravel it. I would generally think 200 feet makes more sense, and I will tell you why, although that is off point. Missouri law gives property owners within 185 feet of the subject property the right to protest a change in zoning. Okay, so there is a logic to providing notice to folks who cover that 185 feet. But we may build an expectation that folks within 300 feet enjoy a similar right of protest, which they don't. But that's not the subject tonight. I just mention it because it's an old war story, and I love giving old war stories.
Very specific dimension, 185 feet. There is, I will look to find the reason for that because I know it exists somewhere, so.
I rather expect it's a legislative compromise, but that's the reason why direct notice is supported, and it's the 185-foot standard, because those folks do enjoy a special status with respect to the capacity to protest that other property owners do not.
Mr. O'Keefe, I know that recognizing what we've done in the past, is there any, and I understand the point of we can do more, but this is the minimum, but we allow ourselves to do more. Considering it's 2024 and electronic notification, is there any consideration of that? Is that something that we do? That's just something that I want to understand how we look at the future.
Again, we can, but what we
We're
don't
not
want to
required to
do
do.
is require it.
Understood, okay. So we can always do more. At some point, maybe we will, not providing any slight to the U.S. Postal Service. I understand that maybe we'll go that direction at some point. Any questions from members of the commission on the text amendment in front of us? Mr. Hunt, you look like you want to say something. Excellent. Mr. Hunt.
You consider stating that maybe the city will have the right to rely on whatever they're provided by the county? As far as that belief standard?
I left it more generic so that if we use private parties to develop the list, or if the applicant, if we require the applicant to provide the notice, mailing list and such, I don't want to, again, undo months of work on a technical failure.
I had questions as well on this one.
Mr. Nolan.
But I think you answered them, but I just wanted to clarify in section 1, is it that it has to be qualified, or it can be a newspaper of general circulation, or no, it has to be qualified?
It can be a newspaper of general circulation.
Okay.
Right.
It could just be a newspaper of general
Yes.
circulation? Okay, so
Right.
I think we might need to say, or which has been qualified.
The fact of the matter is, all newspapers of general circulation are qualified by the circuit court.
But regardless of whether the court qualifies it, it still could qualify for notice.
Let me get the language of the statute. Statute with me at the moment.
I did look at that earlier. I couldn't recall if it was or and. It may have to be that has to be qualified as well.
I'll take a look about whether we can tweak that before action by the board. Okay.
And then I also had a question about, yes, paragraph 1, yeah. I also had the same question Jeff had. I don't, as a practitioner, the staff's belief caused me some concern because that could be subjective. But
Reasonably
given-
believe, has
Yeah,
reason
maybe
to
something
believe.
like that, or
Yeah.
in good faith, or something that would qualify that a little bit, I think would be helpful, but your explanations were helpful.
Yeah, I like the reason to believe.
Yeah.
Or reasonably believe, yep.
After inquiry?
I think if you don't do something to check it, I think you don't have reason to believe that. I'd just as soon stick with has reason to believe.
Know anything else? Vaza?
This is a question, is the Brentwood Pulse considered a paper of general, since it's for our city, or it would have to be the Post-Dispatch?
It does not qualify.
The Pulse doesn't qualify, it'd have to be citywide paper, okay.
And the timing of publication for a newspaper like that also is problematic.
Yeah, just to let you know, because the Pulse publishes only monthly, I essentially had to pre-notice the public hearing in August for this last week, so.
One of the things we don't want to do is establish a circumstance where publishing in a source like the Pulse has to be X days. That's one of the reasons saying you could do other things, but they're not mandatory, they're not necessary. That would allow us to put in, here's the hearings we're going to have, and something like that, in August or whatever, while still not triggering, it has to be there 45 days in advance in order to get published on time.
Yeah, actually, although Mr. Favaz's question raises something to me, which is the state of journalism today. There is every possibility that the Post-Dispatch could stop publishing. Do we have an alternative? Does the Business Journal, for example, which I know publishes a lot of legal and basically contract offerings, things like that, do we have an alternative so that we wouldn't have to stop the business of the city of Brentwood if the Post-Dispatch stops publishing?
There is a legal newspaper published every day, St. Louis County, for the purpose of carrying legal notices. So,
Thank you. That's a great
and they
answer.
have a quick turnaround. You can get it to them on Tuesday and publish on Friday. So,
Excellent. Thank you. Mr. Favaz, anything else? Mr. Carlin?
Just a clarification. So for section 3A, I guess those who the city staff believe to be residents and/or property owners are required to be notified by mail, I think it says. And then in 3B, there appears to be two methods to do that by mail. One is deposited by U.S. mail, or the other is hand-delivered. Is that correct?
yes, sir.
So hand-delivered by city staff counts as by mail?
It counts as delivery, not by mail, but counts as delivery.
So I think that this says be notified by mail in section A. And then, do we have a reason to do either one of those? Do we, do sometimes we use the mail, sometimes we'd hand deliver it, or is there a reason for both of those options?
I don't know what staff's conduct is, but I doubt we often hand deliver it.
We don't often hand deliver, however, there has been a late applicant at the Architectural Review Board, and they really wanted to move forward. So we were like, okay, we'll just revise the agenda and hand deliver it to these 15,
Gives
to
us
the
the
surrounding
option,
properties.
There
yeah.
was development going on in Madge. I got one hand delivered when there was housing.
I asked because there's clearly a different standard of success with those two options, right? One, city staff is required to hand one to each person, and that's something you'd have to do correctly. The other is trusted to the mail, which is a different standard of success, right? So I just wonder why we have both and not standardize on one.
And it's the existing option is there in the code today. We didn't add it, just added the language on how we determine where to go.
Anything else, Mr. Carlin? Other questions? Any questions from members of the public on this text amendment? Sounds like none. Do I have a motion?
Motion to approve the changes with the comments as discussed at this meeting.
For reasonable belief, I believe, Mr. Nolan, is that correct? Correct. Yeah. I have a motion. Do I have a second?
Second?
Roll call vote, please.
Baza?
Yes?
Ms. Sharing?
Yes.
Moore?
Yes.
Hunt?
Yes.
Mr. Carlin?
No.
Mr. Shelton?
Yes.
Mr. Nurnberger?
Yes.
Mr. Nolan?
Yes.
Thank you. Our final item of new business is P and Z 24017. These are text amendments to Section 400-670 of the Brentwood City Code relating to standards for issuance of CUPs, conditional use permits, my apologies. Mr. O'Keefe.
Yes, sir. Again, this is an effort to rebalance responsibility between applicants and the city to establish eligibility for a conditional use permit. Under the existing language of the city code, it currently states that the Board of Aldermen shall approve a conditional use unless it finds that the application and evidence presented indicate that the proposal will increase. It puts the burden on the city to determine that adverse consequences will occur. It is our recommendation that this be more appropriately balanced to say that the applicant bears the responsibility to demonstrate that the adverse consequences will not occur. And we have eliminated that the application is a standard and said it's the evidence presented is the standard upon which the board's judgment is to be exercised as to whether or not the applicant has borne that burden of proof. And we believe this is, first of all, in keeping with generally the responsibility of who bears the burden of persuasion, who bears the burden of going forward with evidence, and who bears the burden of establishing their eligibility. Not that the city establishes they aren't, but rather that the applicant establishes that they are.
Mr. O'Keefe, recognizing that the Planning and Zoning Commission is a recommending body and not a deciding body, does this change anything in our operations? Again, the Board of Aldermen is the one who makes these decisions at the end anyways. Will this alter our practice for cups in any way?
You make recommendations on the same standards. So
Okay.
this also would impose on the applicant before you the responsibility to demonstrate that they satisfy all eligibility requirements.
So the Board of Aldermen would basically, their expectations of what we've reviewed would mirror this. Thank you. Questions from the commission? Mr. Carlin?
Is what constitutes evidence described anywhere else in the code so people?
I'm sorry?
Is what counts as evidence in this case described anywhere else in the code, or just evidence
sir.
as generally understood?
No, we do not specify what evidence is required. That's up to the applicant, how they believe they can best bear their responsibility. And to other interested parties, what do they want to come in with? You know, neighbors who object, or city staff. What is to be presented that finders of fact, you all and then the board, find to be relevant and persuasive?
Anything else, Mr. Carlin? No. Other questions from the commission? Got your finger by the mic, Mr. Hunt. All right.
Yeah.
Mr. Favazza?
Point number 4 will not affect the general welfare of the community. I mean, should it specify will not negatively affect? I mean, or adversely affect? I mean, you're hoping it'll positively affect.
We can, but I didn't want to get too far from what was already there.
Okay.
And so it previously was that we would allow it unless we found that it would affect, presumably, adversely.
I agree. I understand. Yeah, that is a little strange, because anything well, all right.
Well, no, sorry, I actually do agree, because anything will trigger that standard, right? So
I mean, I would make an argument that general welfare means a significant change rather than something that may be at the level of a CUP approval, but.
I would also suggest that if, for instance, in my world, the question is, what would a court say looking back on this process? And if the Board of Aldermen says, this would be a tremendous plus for the community, so we're going to turn it down, I don't think a court would sustain that decision.
Understanding I'm not a lawyer, just knowing that words matter as printed, so.
It's a little strange that it was there. I understand we're trying to change as little as possible to do it, so. Other questions from the commission? Do I have a motion?
I move for approval as presented.
I have a motion by Mr. Hunt. Do I have a second?
Second.
Second by Ms. Sharing. Roll call vote, please.
Baza?
Yes.
Ms. Sherry?
Yes.
Mr. Moore?
Yes.
Mr. Hunt?
Yes.
Mr. Harlan?
Yes.
Shelton?
Yes.
Berger?
Yes.
Mr. Nolan left the meeting at 7:50.
Thank you. That concludes our new business for this evening. Aldermanic report, seeing no alderman present. I just have to keep saying that. Seeing a former alderman present. Director's report, please.
We have received an application for the
And we'll have subcommittee as well. So we'll have two items of business. And I will put in a plug for Jessica, who tries very hard to get us all to RSVP, and we do a horrible job of doing it. So can we please, in this summertime month, make our lives a little easier, myself included, and let her know that we will make the next meeting and subcommittee if we can. Obviously, it would be helpful to have folks there. So anything else from the director's report? With that, do I have a motion to adjourn? Actually, any other business? I always forget to ask. And do I have a motion to adjourn?
So moved.
Motion by Mr. Moore. Do I have a second?
Second.
We stand adjourned. Thank you, everyone. Have a